This podcast explores the workings of the criminal justice system, including the investigation and prosecution of serious offences involving sexual and physical violence. Episodes may contain detailed and sometimes graphic accounts drawn directly from case files, witness testimony and court proceedings, including those involving adult and child victims. Listener discretion is advised. Criminal Justice in Action examines the criminal justice system in England and Wales in practice, how the system works, why it works the way it does, and when and why it doesn't. Each season presents a comprehensive and thought-provoking deep dive into a critical issue in the criminal justice system today. In Season 1, we tackle one of the most contentious issues, the investigation and prosecution of rape and serious sexual offences, or RASO cases as they're increasingly referred to. The criminal justice system's handling of RASO cases and rape in particular, it's a topic that triggers a significant amount of criticism from academics, from activists, from law reformers, the media, the public, and from victims. Because it's so emotive, because it's such a contested, criticised and politicised area, it's a subject where law, facts and reasoned debate can struggle to cut through the noise. And that matters. It matters because it paves the way for myths and misconceptions to prevail. This season isn't about peddling a favoured theory or ideology. It's not about pushing a particular reform agenda. It's about taking a comprehensive, systematic and measured look at how the criminal justice system actually works in these cases, and when it doesn't. Welcome to Criminal Justice in Action Season 1, Rape on Trial. This is Episode 1. It's about 4:25 on a Friday afternoon and I'm sitting in the public gallery of Court 1 in a Crown Court somewhere in England and Wales. The courtroom's almost empty and it's eerily quiet. The judge rose around 10 to 4, not long after she'd put the case into the charge of the jury and sent them out to deliberate on their verdict. So Her Honour's not here. Neither is the jury. Court clerk's not here either. He was clicking away on his computer for a while after the judge left, but then he swept out of court with a piece of paper in his hand. Mr. Neal, prosecuting counsel, and Miss Roberts, the defence barrister, they're here, both scrolling through their laptops. Miss Roberts is apparently catching up with her emails, and Mr. Neal's scrolling through what looks like a witness statement. Presumably he's using this time to prepare for his next trial. Tariq, the defendant, he's also here. He's sitting in the dock at the back of the courtroom along with his interpreter and a custody officer. And then there's me. I wouldn't normally be here. I'm a legal academic, teaching and researching criminal law, criminal evidence, and, well, everything with criminal in it really since 2008. Earlier, if you include my PhD. But when I'm watching Tariq's trial, I'd been on research leave for a good few months by then, traipsing up and down the UK and sometimes beyond, watching criminal trials as part of a research project. And if there's one thing I know, or thought I knew, about jury trials, especially in serious cases, it's that if the jury starts its deliberations late on Friday afternoon, you're not getting a verdict until Monday at best. Usually then, having been away from home all week, I take a late retiring jury as my cue to head off home. But I didn't do that today. I lingered. I don't know why I lingered, but I did. I stayed put. I'm still here, sitting on a crazy uncomfortable seat in Court 1's public gallery, killing time by responding to emails and tidying up my trial notes. Suddenly, there's a flurry of activity. The clerk appears, there's an usher, an urgent whispering about the judge being on her way. I look up. Is it a jury question, I wonder? No, more whispering. Something verdict. I definitely hear verdict. More than once. The jury's coming back with a verdict. No, that's not how this works, I think, as I switch my mobile off. Juries don't come back with a verdict after, 40 minutes? They've barely had time to elect a foreperson, let alone reach a unanimous verdict. And this isn't any old criminal trial, it's a rape trial. Moments later, the judge is in her seat and the jury's filing back into court. and I find myself suddenly dry-mouthed with what feels more like a murmuration of starlings than butterflies in my tummy. I'm genuinely nervous. Not usually nervous, not usually anything. I'm here as an observer, a neutral, impartial, and as objective as I can be observer. I'm here to watch proceedings, specifically how counsel conduct and how trial judges manage the cross-examination of witnesses, especially vulnerable and intimidated witnesses. So it's not that I'm not interested in trial verdicts. It's that I'm here to observe the conduct of the trial itself, and that part's done now. But here I am, late Friday afternoon, sitting in court, waiting for the jury to return with its verdict, heart pounding, suddenly overwhelmed by this sense of dread, this horrible, horrible feeling that the jury's about to get this terribly wrong. I'm getting ahead of myself. To understand my uncharacteristic nerves, my rush of concern that this is all about to go horribly wrong, you need some context. So let me take you back to the start of this trial, to Tuesday morning when we're walking into this particular Crown Court for the first time. We're here to observe a trial that's listed to start in Court 1 today at 10 a.m. All we know right now is that it's a rape trial. It's been listed for 3 to 4 days, and it involves a defendant I'm going to call Tariq. Tariq isn't his real name. In fact, none of the names you're going to hear are the individual's real names. Because of the research protocols and the legal and ethical obligations governing the project I'm involved in, and of course the fact that the law gives complainants in rape cases lifelong anonymity, I'm anonymising everyone and everywhere in the retelling of this trial. But this is a real trial. Aside from names and places, everything you hear is accurate. It's edited down for time, obviously, but it's a comprehensive retelling of real events in real criminal proceedings. So here we are, in the public gallery of Court 1, in a Crown Court somewhere in England and Wales. It's a little before 10 a.m. Prosecuting counsel and defence counsel are already in court. Tariq, the defendant, is in the dock at the back of the courtroom. He's accompanied by an interpreter and flanked by a custody officer. The court clerk enters the court from a small door behind the judge's bench, and he's followed by the judge, who looks to the court as she takes a seat. Counsel nods slightly, and once the judge is settled, she motions for us all to sit. As is the case on the first day of any trial, there are last-minute legal and procedural matters that need to be dealt with before the jury's impanelled and the main hearing, the trial proper as it were, gets underway, and they're being dealt with now. The prosecutor, Mr. Neal, he's telling the judge that there have been some developments in terms of the number of witnesses being called. Instead of the 3 to 4 days originally listed, the trial's more likely only to take 2 days now, possibly going into a third. There's a discussion around what Her Honour calls the batting order, with Mr. Neal telling the judge which witnesses are being called in what order. The plan, he says, is that the complainant's evidence, her evidence in chief, cross-examination and any re-examination will be concluded today. There's a potential problem with one of the prosecution witnesses, Selina, a friend of the complainant's. She's not currently at court and is apparently refusing to come. The judge says this has to be dealt with today. There's an outstanding disclosure issue. It's evidence of messages between the complainant and the defendant via WhatsApp that haven't previously been disclosed to the defence. They need serving. This, says the judge, must be done today. There's also a problem with some relevant CCTV footage. It's no longer available. The officer in the case viewed it previously, says Mr. Neal. She can testify to its content. Miss Roberts, Tariq's defence barrister, she's immediately up, saying she hasn't seen or heard mention of this footage until now. While Mr. Neal may have planned for the complainant's evidence to be finished today, says the judge, there's no conceivable way that cross-examination can go ahead until the defence has been properly served with all the as yet undisclosed evidence and has taken detailed instructions from the defendant. She'll impanel the jury after lunch with a view to trial starting this afternoon. Court rises so that Mr. Neal and Miss Roberts can deal with the various matters that have just been discussed. Court will resume after lunch at 2 o'clock. After lunch, jury selection goes quickly and smoothly. By 2:30, 12 jurors have been selected and sworn in. Once the jurors are all settled into their seats, Her Honour addresses them. She explains the separate roles of the judge and the jury, that they will be judging the facts, and she's dealing with matters of law. She tells them that they're trying a rape case, that they must put aside any assumptions or preconceptions about rape they may have, and assess the case on the evidence dispassionately. Don't talk to anyone about the trial, she tells them. Don't do your own research. Let me know about any intimidation. She explains that they're going to get different types of evidence during the trial, video evidence, statements read in, and it's all to be assessed the same way. Tells the jury they've each got a paper and pencil, but she'll be summarising the evidence at the end, so they don't need to worry about taking extensive notes. It's standard start of trial fare, and it takes about 10 minutes. Mr. Neal then takes to his feet and opens the prosecution's case. Mr. Neal's the quintessential bit of a tough barrister. Rhetorically, he's a bit flowery in places, but he's neither pompous nor arrogant, quite the opposite. He's quietly dignified, speaks with a measured authority and a kindly, compassionate tone, affable and amiable. He begins by introducing himself and tells the jury he's prosecuting this case on behalf of the Crown. He also introduces Miss Roberts. She's acting for the defendant, Tariq. Mr. Neal then points to a large wall-mounted screen on the opposite side of the court to the jury. On it, there's a still image, a picture of a young black woman sitting on a bus. She looks small, not small like a child, small as in curling in on herself like an autumn leaf, and she is clearly distressed. There's another woman in the picture too. She's standing in front of the patently anguished passenger, and while the standing woman's uniform says ticket inspector, her stance says concerned auntie. It's a powerful image. After he's given the jury a moment to take that picture in, Mr. Neal tells them it's a still taken from CCTV footage from a bus showing, quote, the clearly traumatised complainant, young Ruby, 18 at the time, after she'd left that gentleman's business premises after an encounter with him, which is the subject of the indictment you have in your jury bundle. As I say, it's a compelling image, and it stays up on that screen for the duration of Mr. Neal's opening speech. He directs the jury to the indictment, a document setting out the two charges for which Tariq's now on trial, one count of rape and a second count of false imprisonment. Mr. Neal then gives the jury an overview of the prosecution's case. He tells them that on the day in question, Ruby, a teenager, was, as far as she was concerned, going for a perfectly conventional job interview. With the benefit of hindsight, he says, the wisdom of hindsight, when Ruby looked back at the setting up of that interview, she had reservations about some questionable and, he says, arguably unprofessional acts on Tariq's part. Ruby had seen a job online for care workers. The advert contained a mobile telephone number which she'd contacted. It was Tariq's number. There was a photo of Ruby in a bikini on her WhatsApp status, says Mr. Neal. Nothing alluring or suggestive about it, he says emphatically. Simply a photograph of her reflection in a mirror while wearing a swimsuit. Tariq had responded directly to that photo rather than in the main conversation thread, posting, "Hi, how are you?" Ruby didn't think that was appropriate, but, says Mr. Neal, she's pursuing a job opportunity, so she sends him her CV when she's requested to do so, and so on, and she conducts all her exchanges with Tariq in the body of the conversation thread. An interview is arranged for the following week. Although the advertised job was for care workers, Tariq was now looking for a secretary. Having looked at her CV, Tariq said Ruby had no relevant secretarial experience. And what better way to remedy that than to offer some training, says Mr. Neal. Ruby agreed to undergo secretarial training from 10 a.m. till 5 p.m. on the day of the interview. Tariq told her she'd get a certificate at the end. When Tariq offered to pick Ruby up and give her a lift on the morning of her interview/training, Ruby declined. She made her own way to the office. Up to this point, says Mr. Neal, Ruby was under the impression that Tariq's company was substantial. When she got to the relevant premises, she was reassured by what Mr. Neal now describes as the building's impressive facade. Once inside, however, Tariq's small, cramped office filled with oddments of furniture was somewhat underwhelming. The training, too, wasn't what she'd expected. She was given pointless tasks to complete, none of which seemed to have much to do with secretarial skills. The Crown suggests that all of this was essentially a pretence, Mr. Neal tells the jury, the purpose of which was simply to draw out Ruby's stay. Tariq asked personal, sometimes intimate questions. He mentioned the bikini profile photo and joked that she hadn't invited him to her account as a friend or a contact. When he learned she'd studied dance, Tariq said she should demonstrate. He got a prayer mat out from the cupboard, laid it on the floor, made several entreaties for her to dance for him, all politely declined by Ruby. He'd asked her if she was single. At this point, says Mr. Neal, Tariq told Ruby he needed to pop out to the post office. He was gone, leaving Ruby alone in the office for around 10 minutes. When he returned, says Mr. Neal, personal matters were pursued again by him, and again not appropriately. Tariq showed Ruby photos of his girlfriend, his holiday snaps, all designed, says the prosecutor, to make Ruby more likely to reciprocate. Mr. Neal now sets out a basic account of the alleged assault, how Tariq asked Ruby to look for some papers in a box, how he'd approached her while she did so, told her that the job was hers, albeit that he couldn't pay her and she'd have to work as an unpaid volunteer, an intern, as it were. Once again, Tariq asked Ruby to dance for him and started to play music on his phone. Now, says Mr. Neal, the whole episode began to take a jolly sinister turn. The prosecutor describes Tariq advancing on Ruby, bearing down on her, pinning her to the wall, kissing her, pleading for her to give him just one kiss, with Ruby making it abundantly plain that this was not welcome, that she's then pushed down to the ground and raped. And as Ruby struggled and screamed, he tells the jury, Tariq simply reached for his phone and turned up the volume on the music that was playing. When it was over, Ruby grabbed up her belongings and went to leave. Tariq, however, told her she couldn't leave, she hadn't completed her training. When she went for the door anyway, Tariq forcibly blocked her exit until Ruby had promised not to tell her friends. And then, members of the jury, says Mr. Neal, in perhaps the most devastating afterthought, but one full of implied meaning, you might think, he told her he hadn't paid her for today, and that if she came to a cash point, he would give her the money that was due her and let her go. And she did this, automaton-like, and Tariq then left her to get that bus you see up on the screen. She, traumatised, weeping, her trousers soiled and wet with his semen, says Mr. Neal. He tells the jury that what Ruby did after this encounter, where she went and the reports she made, they'll be revealed in evidence in due course. But, he says, as the jury will have gathered, a complaint was made to police leading to Tariq's arrest and interview. He takes the jury back to the indictment document. In respect to count 1, the rape count, Mr. Neal says, the prosecution cases there is absolutely no prospect of you finding that Ruby consented to her violation. Likewise, we say that there is no conceivable argument that would cause him to believe that she had done so, reasonably or otherwise. On count 2, says Mr. Neal, the prosecution's case is that in detaining her post-rape, Tariq held Ruby against her will inside that claustrophobic room. He falsely imprisoned her. In his police interview, says Mr. Neal, Tariq set out his answer to the indictment. That answer centres upon the unbridled consent, he says, to every aspect of the sexual encounter that they'd enjoyed as he represented it to officers. Indeed, not only did she consent, she had, by his lights, initiated it. According to Tariq, Mr. Neal continues, Ruby showed him her WhatsApp profile picture when he returned from the post office. She danced for him on his prayer mat. She put the music on his phone. Sexual intercourse, according to the defendant, was a natural consequence of all this precursor activity, she eagerly cooperating. As for the false imprisonment, on Tariq's account, Ruby had begun to feel unwell. She also had another appointment. There was no question of him resisting Ruby's leaving. In fact, according to Tariq, he'd offered to reimburse her travel expenses and so took her to the cash point and gave her £20 for her trouble. So that, members of the jury, Mr. Neal concludes, is the way the land lies in this case. There's a slight pause before he continues. Now, the Crown bring these complaints against Tariq, and you come to these proceedings presuming that, in respect of both of those counts, that the Crown is entirely wrong about this defendant. And that presumption of his innocence, as you are very well aware, endures unless and until the Crown has satisfied you so that you are sure that you can safely discard it. With the gravity of proceedings thoroughly underscored, Mr. Neal tells the jury they're about to see Ruby's video evidence, an interview with police which serves as her evidence in chief. It's 17 minutes past 3, and the prosecution's evidential case is about to begin. It's now 20 past 3, and although Ruby's pre-recorded video is up on the court screen, it's been paused. There's a problem with the audio. It'll only play through Mr. Neal's laptop speakers, and that, of course, is far too quiet for the jury to hear. The judge asks if this was checked prior to being played, and Mr. Neal has to admit that no, it wasn't. The clerk, Mr. Neal and Miss Roberts, are now all furiously clicking computer keys on the prosecutor's laptop and on the court's computer system, but nobody can work out what's gone wrong. The jury are asked to leave the courtroom while the problem's sorted out. This is a crucial piece of evidence, the judge tells them, and poor sound is not acceptable. If the problem can't be resolved by 3:45, she says, then the evidence will be played tomorrow. The problem isn't resolved by 4:45, and the jury's sent home. Once they've gone, the judge's displeasure with the lack of preparation on Mr. Neal's part is made very clear. Court rises, back tomorrow morning at 10. It's 10 o'clock on Wednesday morning, and we're back in Court 1 for day 2 of Tariq's trial. The jury isn't here yet, but counsel are, and so is the judge. Mr. Neal's telling the judge about the ongoing problem with the prosecution witness, Selina. Selina's a friend of Ruby's, and Mr. Neal was intending to call her this afternoon as a witness. She's not currently at court, she's refusing to come to court, and following further inquiries yesterday, it seems that the reason she's not coming to court is because Ruby's told her to stay away. This, says the judge, must be investigated today. The police need to contact Selina and get a statement. With that, the jury's called in, and once they're back in their seats, Ruby's ABE video is played to the court. It's just shy of 3/4 of an hour long. In the video, Ruby's in a specialist interview suite. She's on a large sofa behind a low table, like a coffee table, with a microphone on it. There's an officer sitting in front of her. The officer's closest to the camera, but with her back to it. As Ruby tells her story, she fiddles incessantly with a tissue. It's this account that the prosecutor's opening speech was based on, so I'm going to summarise it, reduce it right down. Ruby tells the officer she'd seen a job advertised online. Her friend Selina had told her about it. The ad was for care work, but Selina said the guy was looking for a secretary. Selina couldn't do the hours. Maybe Ruby'd be interested. She was. She sent a text to the mobile number listed in the ad, and Tariq responded. Her antenna were up immediately, she says, because Tariq responded to a photo on her WhatsApp status. She thought that was peculiar. She'd sent him her CV like he'd asked, and he said she didn't have the relevant experience. He offered to interview her anyway and give her some training, and she agreed. Ruby says he contacted her the night before the interview, offering to give her a lift. She had a little trouble with that offer, but she pushed those doubts to one side. She'd made her own way to the interview. When she got to the office, she was again a bit thrown because the officers weren't quite what she'd understood them to be. She was under the impression that she was attending the head office of a pretty substantial company. In fact, it was just one small rented room in a larger office building that a lot of other companies worked out of. She and Tariq had chatted about the role, and then her training began. She was happy to do the training, she says, because she wanted a job, but it wasn't real training. She was given pointless tasks to do, like doing research on Google, memorising what she'd found. While she was working, Tariq had asked all sorts of questions about the photos on her status, about her not friending him on social media, and about her college studies. She told him she'd studied dance, and he asked her to show him, to dance for him. She'd said no, made excuses that she'd need to stretch and warm up, but he got a prayer mat out of the cupboard for her to dance on. She continued to say no and carried on with her work. Then he asked if she was single. She told him that yes, she was. All of this, she thought, was unusual. Then Tariq said he needed to go to the post office. He went out and left her in the office on her own. While he was gone, Ruby took a video of the office on her phone and sent it to a friend with a message, "What the fuck? This is the office, guys." When Tariq came back, things changed. More inappropriate questions and conversation from Tariq, showing her photos on his phone. Then he'd pointed to a box on the table and asked her to look in it for a paper. And while she was looking, he approached her. He's asking her again about the dancing. But he's playing music now on his phone. She's retreating, he's advancing, she's pushed up against a radiator. He's touching her, kissing her, trying to pull her trousers down, and she's saying no, no. He pushes her down to the floor, then he rapes her. All the while she's screaming and crying, but he doesn't stop. But he turns the music up on his phone to drown out her cries. When he'd finished, he cleaned Ruby and himself with tissue. Afterwards, she says, he wouldn't let her leave. She hadn't finished her training, he told her, and if she didn't stay, she wouldn't get paid for the day. She tried to leave anyway, but Tariq blocked the door. He asked her if she was going to tell her friends. Eventually, he said he needed to pay her. They left the office, he took her to a cash point and gave her £20. Then she got on the bus into town. She was crying on the bus, she said. I just felt like I couldn't breathe, she's saying to the officer. The ticket inspector came onto the bus, and because I was in the very first seat, she came up to me first, and I was crying, and she said, "Are you okay?" And at first she asked if I'd got a ticket, and I was just like, I paid when I got on, and I was crying. She could see that I was distressed. She said, "Are you okay again?" And I said, "Yeah, I'm fine." And then she walked on to the other people. When she got into town, Ruby went to a chain store. She bought new underwear, pants. Then she went to a chemist and bought the morning after pill. She was still crying, she says, and the pharmacist asked her if she was okay. I said, "Yeah, I just want the pill." She'd arranged to go to her friend Tia's house after her training, so she just went, as planned. When she got there, she asked to use Tia's shower and washed herself. Tia could obviously see something was wrong, but Ruby told her she didn't want to talk about it. Tia wanted to go into town, something about a broken nail and needing to go to the nail bar, and then maybe meeting up with a couple of friends of theirs, Selena and Melody. Ruby went along. They ended up going for something to eat. Ruby ordered her favourite meal, but she didn't touch it. Her friends could see there was something wrong and they were pushing her to talk to them, but she told them, "If I start talking about it, I'll just start crying." That night, she had a video call with her mum. Mum could tell there was something wrong. She kept asking Ruby questions. She didn't tell her mum exactly what had happened, just that he'd touched her. Mum told her to go to the police and to take her sister with her. They'd gone to the local police station the following afternoon, but it was closed, so they went home and Ruby called 999. With that, the screen goes black. It's the end of Ruby's evidence. Court immediately adjourns briefly so the jury can take a break, and so Miss Roberts can take instructions from Tariq. It's a good 50 minutes before the trial resumes. When we get back from the break, Ruby's in court. She's going to be cross-examined live. Now, this could have been done via a video link with Ruby somewhere other than here in Court 1, but she's opted to be in court instead, but she's behind a screen. The screen means Tariq can't see her, and she can't see him. We don't go straight into cross-examination, however. First, Mr. Neal, prosecuting counsel, tells Ruby he has one or two additional questions. You understand that we've seen a video of an interview that was conducted way back last year between you and the police. Yes, says Ruby. He asks about the video she took of the office while Tariq was at the post office, the what the fuck video that she'd sent to her friend. The video's now playing for the jury on the court screen. It's a silent, shaky video recording that scans a small, sparsely furnished and yet still cramped and untidy office. Why did you do that? Mr. Neal asks. Because, he made out he'd got a big company, says Ruby. When I got there, I was taken back. The office was so small, there was nothing there. Ruby and the court are now directed to a number of photos of the office. The jury have these photos in their bundle, and using those photographs, Mr. Neal takes Ruby through the physical layout, where everyone was at various points that morning. Where was she? Was she sitting or standing? Which desk? Where was Tariq? Then where was the box she was asked to look in? Can you remember precisely what was in there when you went in to look at it? 3 sheets of plain paper, says Ruby. Mr. Neal's now asking Ruby about where the rape itself took place. She's up against the radiator, she says. Mr. Neal hands her a pen. Could you just draw for me 2 little stick figures, one representing you, one representing him, so we can all see what you mean, he says. Ruby, obviously, we can't see her, but she marks on the photo where she was pinned and where Tariq was. The usher shows the annotated photograph to the defendant, then to defence counsel, the judge, and finally to the jury. Mr. Neal then moves to the WhatsApp messages and Ruby's profile pictures, and he establishes a critical distinction that wasn't clear in the ABE video. Ruby's asked to identify 2 photographs. The first one, she says, is my WhatsApp picture, and the second one's on my WhatsApp story. Now, the first picture, her profile picture, that's of Ruby with a friend's baby on her knee, and that's the photo that automatically appears alongside Ruby's name if she was in your list of contacts. The second photo, the photo of Ruby in a swimsuit that Tariq had commented on, that photo's in her story, and that's a separate public space in the app. And it's one of a number of photos in her story. It's the only one of her in a swimsuit, and it's the only one Tariq responded to directly. Mr. Neal covers the text exchange between Ruby and Tariq on WhatsApp. All the messages have been downloaded from Ruby's mobile phone and printed off, and copies of the messages are being distributed to the judge and the jury now. Now, we can't see these printouts and they're not being displayed on the screen, and they aren't all being read out, but 2 things are very clear. First, it's the entire exchange from Ruby's first contact having seen the ad, sending in her CV, providing her ID and setting up the interview. But there are some additional messages that Tariq sent to Ruby the day after the alleged rape. We don't know what those messages are because we can't see them, and Mr. Neal hasn't read them out. All we know is what Ruby is confirming now to Mr. Neal, that she didn't respond to any of those messages from Tariq after her interview. Finally, Mr. Neal clarifies a few finer details about how Ruby found the job advertisement, and then he tells the judge he has no more questions. The judge does. Her Honour leans forward slightly towards Ruby. Ruby, she says gently, if I could just ask one question, to be absolutely clear. The video that Mr. Neal referred to, the one that you made with police officers last year, were you telling the truth when you made that video? Yes, Ruby answers. The judge nods. Yes, Miss Roberts? It's time for cross-examination. Miss Roberts stands, gives the black robe that's sliding down her back a bit of a tug and a winch, and addresses Ruby. Well, Ruby, she says, I'm now going to ask you some questions on behalf of the defendant, all right? What's important is your answer, Miss Roberts is saying. I'm going to suggest some things to you, and it's for you to either agree or disagree with them, okay? Okay, says Ruby. Miss Roberts now spends about 10-12 minutes going over what seem to be quite mundane, trivial details, where the job was advertised, that a friend had alerted Ruby to the relevant ad, the times and dates of the messages between the complainant and Tariq setting up the interview, where precisely the office building was. Then she asks Ruby to confirm that she knew Tariq had viewed a number of photos and videos on her WhatsApp status, including the swimwear photo, and that she knew that they'd been viewed 2 days before the interview. Yes, says Ruby. She checks that Ruby had told the police that this was a, quote, alarm flag. Yes, agrees Ruby. That knowing Tariq had viewed those images, Ruby hadn't then taken them down. No, says Ruby. And that even though Ruby felt this was an alarm flag, she still decided to go to Tariq's business address on the day as arranged. Yes, agrees Ruby. It's a subtle undermining on Miss Roberts's part, rather than a gotcha moment. There's no overt hostility, no feigned incredulity, no accusations that Ruby's lying or laying it on a bit thick. Just this unspoken insinuation, well, if you already knew this man was looking at your photos, if your alarm flag was already up, why did you even go? And it's left hanging in the air. Miss Roberts, having made her point, moves on. There's now another 10 minutes or so of, again, mundane yes-no questions about the office building that honestly don't seem to have much to do with anything. She's asked Ruby about the other companies she'd noticed that worked from the same building, what lines of business they were in. Maybe it's an effort to make the unimpressive office seem more impressive, I don't know. Whatever Miss Roberts's point here is, she doesn't explicitly make it, and if we were supposed to infer it ourselves, if it's another insinuation, well, it's gone right over my head. Now we're spending an inordinate amount of time on where the door to Tariq's office was in relation to the stairs and landing and what colour the door was. It might not matter, says Miss Roberts, and honestly, I can't say I have any idea why any of this would matter, but it might not matter, says counsel. I'm just trying to get my bearings. Finally, with whatever point she was trying to make here utterly beyond me, Miss Roberts moves on. She's asking now about when Tariq left the office. Right, so he's left the office, says Miss Roberts. By that stage, were you uncomfortable being there? Yes, says Ruby. When he left, he didn't lock you in, though, did he? No. You could have left at that point if you'd wanted to. Yes. If you were uncomfortable, the door was open, it wasn't locked. You could leave. I guess so, says Ruby. But you chose to stay. Yes, I thought it would be a bit unprofessional just to leave when he'd left. And you took this video, why? Because I was speaking with my friend and I was saying how, look at the office. Because he was saying how, so basically he had, another business with somebody else. So this was like a new thing he was doing, like a new building. So I was kind of taken back. So I sent it to my friend and she was going to call me so I could leave. And did she phone back, asked Miss Roberts? By the time she called me, I'd left. Right, so with regard to timings, says Miss Roberts, you said to her to phone you. Was there any sort of time for her to phone you? I said, within the next half hour. So you thought it would be unprofessional to just leave? Yes. Miss Roberts moves immediately onto the conversation between Ruby and Tariq when he got back from the post office, that they were talking about holidays, yes. That Tariq had told her he'd looked at her profile photo. Yes, the conversation about dance and gymnastics. And did he ask you to perform some gymnastics for him, counsel asks. Yes, says Ruby. And at this stage, is this when the rug was produced? Yes. And you did do some leg stretching on the mat, is that right? No, he kept asking me to. And he asked if he could stroke your leg, and did he, didn't he? The judge interrupts. Pause there, she says to Miss Roberts, and then turns to Ruby. Did he ask to stroke your leg? The judge asks. No, says Ruby. Did he stroke your leg? Asks the judge. No. Miss Roberts resumes her questions now. And in relation to the dancing, you did dance with him, didn't you? No. He asked you to teach him to dance, didn't he? Yes. And he handed you his phone so you could select some music? No. Did you touch his phone? When he showed me photos, says Ruby. When he was showing me, I was touching the phone, yes, but that's the only point. And at this stage, says Miss Roberts, you didn't try to leave, did you, Ruby? No, says Ruby. Her voice is getting a lot quieter now. And you began to show him some dance moves, didn't you? No. Holding each other, arm in arm, did that happen? Now, we don't hear Ruby's answer to this. Whether that's because she said it quietly or because she shook her head, I don't know. Remember, we can't see Ruby, she's behind the screen. But you can hear sniffing and some erratic breathing now. It sounds like Ruby's crying. Certainly she sounds distressed. But she's obviously communicated that no, that didn't happen, somehow. And Miss Roberts is moving on again. She asks a series of questions about the incident at the heart of the trial, what Miss Roberts is presenting on Tariq's behalf, on his instructions, as a consensual sexual encounter. Ruby consistently disagrees with this portrayal. Yes, he'd asked if he could kiss her. No, she hadn't agreed that he could. No, she'd told him she didn't want to, that she was moving her face away, trying to avoid his kisses. No, at no point had she let him kiss her. Yes, he had touched her breast, but again, no, she hadn't let him. No, she hadn't allowed him to pull her trousers down, as Miss Roberts is suggesting. She did resist. She was saying no. She hadn't laid herself down beside him on the floor. She hadn't pulled her own trousers down. She hadn't let him touch her. It's the defendant's case, says Miss Roberts, that you let him do all of this up to this stage. Is that right or not? No, says a clearly weeping Ruby, emphatically. Miss Roberts now suggests it was only once Tariq had inserted his penis, an act which caused Ruby some pain. It was only then that Ruby asked him to stop, and that as soon as Tariq realised he was hurting Ruby, he had immediately withdrawn. Ruby doesn't agree with any of this. Miss Roberts presses on. You told the police that after he'd withdrawn his penis, Tariq ejaculated. Yes, Ruby agrees. She's asked if Tariq wiped her with the tissue or whether she'd wiped herself. He did that, says Ruby. She's asked how long she remained in the office afterwards. No longer than 5 minutes, says Ruby. Miss Roberts asks whether after Tariq had wiped her, they carried on talking normally. No, I just went to get my bag. You went to get your bag? Did he say anything to you? Asked Miss Roberts. No, he just kept telling me to stay. He didn't say this in an angry fashion, did he? No. He just wanted you to stay. Yes. And was that the words that he said? He told me that if I left now, I wouldn't be able to, continue the training, says Ruby. He didn't stop you from leaving, did he? Yes. He didn't put his hand on the door handle, did he? Or put his foot against the door? Yes, he did. When was the discussion to go to the bank? Was it inside the office? It was at the door, says Ruby. He said if I'd come to the bank, he'd let me go. So what did you say when he said that to you? Asks Miss Roberts. I said it was okay, that I just wanted to go home. Miss Roberts now asks whether when they got to the exit of the building, Ruby then made her way home. I went to the bank and then I went home, says Ruby. If you just wanted to go home, asks Miss Robert, why did you go to the bank with him? I don't know, says Ruby quietly. You walked to the bank with him? Yes. And during that time you and he were chatting, weren't you? No. He didn't have hold of you, did he? No. Prevent you from leaving? No. You walked together. This was a weekday. A busy day, wasn't it? Not really that busy, says Ruby. There were people on the street, not just the two of you. Yeah. Did you try and get some help from anyone else? No. Did you stop any of them? No. And when you got to the bank, you didn't go inside, did you? No, says Ruby. It was a cash point machine, wasn't it? Outside the bank? Yes. And he went to use the cash point, is that right? Yes. And what did you do? I just stood there. And he asked you how much money you needed, didn't he? No. You say you just stood there. In fact, you came towards him in the machine, didn't you? Asks Miss Roberts. I don't know. I don't know whether that's right or not, says Ruby. And you were standing next to him. I know I was standing by him, says Ruby, but I don't know that I came towards him. And he took out £20 and handed it to you. Yes, says Ruby. Did you take it or not? Yes, I did. Miss Roberts now says that Ruby and Tariq walked together to the bus stop and that Tariq had waited with her for the bus, that they were talking at the bus stop, that he'd asked her to come back to the office later that week and that Ruby had agreed. She'd arranged to go back at 3 o'clock on the Friday after college. Ruby rejects all of these propositions. Unsurprisingly, Miss Roberts skips very quickly over the bus journey we've seen the footage from this morning. She simply states that Ruby caught the bus, went to a clothing store, onto a pharmacist, but that's it. That's as much as she says. She also skips over Ruby going from the city centre to her friend Tia's house and showering. Instead, she moves straight on to Ruby being back in town with Tia later on. Who wanted to go to the nail bar? She asked casually. Tia did, says Ruby. Did you have your nails done? No. Ruby agrees that she and Tia then met up with Selena and Melody and that no, she didn't tell them what had happened. I just said that he had me up against the wall and tried to kiss me, she says. Ruby agrees that the four friends went on to get something to eat. You didn't contact the police that evening, asks Miss Roberts. No, it was the following evening, says Ruby. Miss Roberts then directs Ruby back to the printouts of the text messages between her and Tariq. Those printouts show 2 deleted messages sent from Ruby's phone to Tariq around 10 o'clock on the night of the incident. Ruby agrees that yes, she sent and then deleted those 2 messages. She can't remember what the messages said. About 5 a.m. the next morning, Tariq had messaged Ruby asking what she'd deleted. Ruby didn't reply. A couple of minutes later, Tariq sent Ruby 3 further messages, all along the lines of negotiating the terms of her voluntary work. Ruby again says she can't remember what her 2 deleted messages said, and she didn't reply to any of the messages from Tariq. Now, says Miss Roberts, finally this. It's the defendant's case, Ruby, that you agreed with him and by your behaviour consented to have sexual intercourse with the defendant. Is that right or not? No. And it's only afterwards that you regretted it? No. And were embarrassed? No. But what happened in the office that day was with your consent. No, it wasn't. Thank you very much, says Miss Roberts. I have no further questions for you. Neither does the judge, but Mr. Neal does. Very, very briefly, Ruby, says Mr. Neal. It was put to you that when you walked to the bank with the defendant, you didn't try to seek help from anybody in the street. Was there in fact anybody in the street to whom you could run? I don't remember, says Ruby. You don't remember. In any event, you were on the face of things walking with him. Yes, she says flatly. And at the bank machine it was put to you that you came towards him, to which you said, I don't know whether that's right or not, correct? Yes. And that you accepted from him the money that he gave you? Yes. And then afterwards you went to the bus stop. He had asked you if you'd come back and you said, I don't know. So you understand what's being put to you there, says Mr. Neal, that you had consented to sexual relations in the office and that your behaviour on the way to the bank, failing to seek help, etc., was a piece of that. Yes, says Ruby. If you had to describe how you were feeling on that short walk to the ATM in one word, says Mr. Neal, would you have a go at that for me? I don't know, she says. Scared? Anything else? I just felt sick. Tell me about your logical thought processes and how they were working at the time, asks Mr. Neal. Ruby does give a brief answer here, but she's really quiet and flat by now. She sounds exhausted, and I can't make out what she's saying, but I can see that the jury's leaning in. They're listening intently. They really haven't taken their eyes off her since she got in the witness box. Mr. Neal continues, It's been put to you, he says, just at the end of my learned friend's cross-examination, that you are inventing this allegation, as far as lack of consent is concerned, because you were embarrassed at what had gone on in the office, yes? Yes, says Ruby. That's what was put to you, you understood. How are you feeling today, standing in that witness box, relating your account of those events to this jury, please? I don't know, says Ruby, I don't remember. I'm sorry, says Mr. Neal. He looks up from his notes. He looks surprised. How are you feeling, is what I'm asking, he says, at this moment. I feel sick, she says. The flatness of that quiet voice is devastating. You feel sick? asks the judge. Yes. You feel sick, repeats Mr. Neal. And the course of the investigation, which has lasted several months and has involved you being interviewed on video by the police and having court dates and so on and so forth, how did that process make you feel, please? asked Mr. Neal. She takes a moment before she finally says quietly, almost in a whisper, I didn't feel like myself. I'm sorry, says the judge. I didn't catch that. I didn't feel like myself, says Mr. Neal. I didn't feel like myself, says Ruby. The judge thanks Ruby and says she'll be allowed to go in a moment. It's unlikely that you'll have to come back to court, she tells Ruby, but she mustn't discuss her evidence with anybody else at all. The jury's sent for lunch and the court is cleared. That means anyone in the public gallery and the defendant sent out of the courtroom so that Ruby can leave the court without being observed. It's just after 1. In total, Ruby's spent about an hour and a quarter in the witness box this morning. 20 minutes of live evidence in chief with Mr. Neal, 49 minutes in cross-examination with Miss Roberts, and a further 3 minutes of re-examination by prosecuting counsel. Plus, of course, the 3/4 of an hour or so of her pre-recorded video evidence that was played to the jury first thing. Ostensibly, then, Ruby's evidence is now complete. The prosecution case will resume after lunch. Absent Ruby. After lunch, the jury's brought back in and trial resumes. Mr. Neal tells the jury they're about to hear the audio recording of the 999 call Ruby made to the police the day after the incident. The recording comes through the court speakers. We hear the operator introduce herself and Ruby saying she wants to report a crime. The operator asks if it's happening right now. No, says Ruby. She went to a job interview yesterday and was sexually assaulted. The audio is lousy. Ruby sounds like she's underwater and the feedback is horrible. It hurts your ears and it's really distracting. Certainly I'm concentrating on how bad the audio is rather than what's being said. Turns out it's not just me. The operator's now saying much the same thing to Ruby and she's asking if she's got her phone on speaker. When Ruby takes the call off speaker, the audio's better. It's still not great, but it's better. What then follows is odd. Instead of the usual bare-bones account in a 999 call, the operator's taking a full detailed account from Ruby. To be sure, Ruby's doing most of the talking. She's giving her account largely unprompted, but the operator, who isn't a police officer and isn't trained to take statements, let alone interview a rape complainant, she isn't closing the conversation down, for want of a better term. So what we're hearing right now then in this recorded 999 call is an almost verbatim repeat of the evidence that we heard this morning in Ruby's ABE video. After 5 minutes of this, the judge interrupts and the recording's paused. There's a problem with the audio in the dock, the judge explains. The defendant and his interpreter are struggling to hear the evidence, as of course are we. The jury sent out while the matter's resolved. It's not an issue with the sound system in the dock. The problem is purely down to poor audio quality. The solution, it's decided, is to give the interpreter a transcript of the call. To everyone's astonishment, it turns out the interpreter already has that transcript, but for reasons unfathomable, he hasn't been using it. But with the jury out of the courtroom, the judge raises the same issue we've just been thinking about. The nature and content of this 999 call, which, says the judge, is a voluminous, verbatim account of what she told the police in her ABE. Mr. Neal agrees. That's the point, he says. It's the same account being given twice, says the judge. We don't normally have the same account being given twice in front of a jury. That simply doesn't happen. This is essentially a repeat interview. The playing of the call's obviously been agreed by the parties, she says, and she won't interfere. But, she says, it seems superfluous in the circumstances. Mr. Neal disagrees. It shows Ruby's consistency, which reinforces the Crown's case, he says. In my submission, the call should be admissible. It is admissible, says the judge. It's just whether it needs to go in the form it has. With that, the jury's brought back in to hear the remainder of the 999 call. Mr. Neal hits play, we get a couple of words, and then nothing. The audio's gone down. Again, it turns out that the file upload or the file download, whichever way the loading went, it wasn't complete. The judge is not impressed. A file needs to be checked before we start playing it in front of the jury, she says sharply. We had the same problem yesterday with the audio on the ABE. It needs to be checked against court equipment before wasting the jury's time, says the judge. And mine. Mr. Neal abandons the 999 call and presses on. He tells the judge there are some witness statements to be read into evidence. The judge gives the jury a standard direction, explaining that witnesses aren't called when their evidence isn't challenged. Instead, their statement is read to the court. What you make of the evidence is up to you, says the judge, but you don't have to decide whether what's recorded is true or accurate. It's agreed between the parties that it is. First, there's a statement from Carol, Ruby's mum. In her statement, Carol explains that she'd spoken to Ruby on the day in question on a video call as she was away at the time. Ruby had said she was missing her mum and was missing her more that day, that she'd had a bad day. She'd been for a job, that it wasn't a real job, and Carol says she could see something was wrong, but she didn't know what, and Ruby wasn't telling her. Mum's asking questions about the interview, and Ruby's told her that he was asking inappropriate questions. Mum asked directly if he'd touched Ruby, and Ruby became distressed and said yes. Mum asked what he'd done, but Ruby didn't answer. She told Ruby to report it to the police the following day. Ruby was very upset and said she had to go to college. I didn't want her to go, Carol says in her statement, but she said she had to. I told her to relax for the evening, but to report it the next day and to take her sister with her to support her. They did. They went to the local police station after college the next day, but it was closed. When Carol spoke to Ruby later that night, Ruby told her that she'd called the police, that she'd given a statement over the phone, and that the police were going to come and collect her clothes. When Carol tried to push Ruby again around what had happened, Ruby didn't want to talk about it. Carol says she only found out the full extent this morning, as in the morning that she's given the statement to the police. Carol said that Ruby wasn't being her normal self and the police taking her clothes had made her think there must be more to it. She'd then asked Ruby directly if the man had raped her. Ruby started to cry and said yes. That's the end of Mum's statement. Next, there's a statement from Melody. Melody states that on the relevant date she was in town with her friend Selena. They found out that Ruby was also in town with another friend, so they all met up. Melody's known Ruby for a few years. She describes Ruby as very bubbly, energetic, always smiling, and a really positive person to be around. She states that Ruby wasn't her usual self that day. She was very quiet. Selena was also worried about Ruby, hugging her and asking her if she was okay. Melody says as she and Ruby weren't as close, she'd stepped back so Selena could speak to her. Melody says they all went to the restaurant and ordered food. She says Ruby loves this particular restaurant and always has the same meal. Ruby ordered that same meal this day, but wasn't really eating it, she was just picking at it. The statement finishes with Melody saying she especially remembers this day as Ruby wasn't her usual self and it stood out. She says she hasn't seen Ruby since and doesn't know what might have happened before they all met to make Ruby so upset. Next, a statement from Olivia. Olivia is a friend of Selena's. Olivia's statement says that Selena had mentioned that she had the telephone number of a man who had lots of jobs going. His name was Tariq. Olivia had messaged him to inquire about work, and Tariq replied asking for her name and email address. He mentioned having a number of jobs available, but he never got back to her, so she blocked his number later on her phone. That's it. End of Olivia's statement. The final statement to be read in is from Tia. Tia says that she and Ruby have been friends for a few years, that Ruby came to her house after she'd been for some training. Tia says that when Ruby arrived at her house that afternoon, she asked if she could use the shower. After Ruby had showered, she wouldn't say anything. I could clearly see she wasn't herself and wasn't comfortable talking about it, Tia says in her statement. Later on, Tia wanted to go into town, but Ruby didn't want to do anything, says Tia. I asked her why she was acting weird. Ruby then told me that he'd pinned her up against the wall and that every time she asked him to stop, he'd turn the music up louder and louder to muffle her, and he was making weird comments. Tia's statement finishes saying Ruby hasn't told me anything else and I've not asked because she's uncomfortable talking about it. That's the end of the written statements. Mr. Neal's now going to read some further agreed facts into evidence. This, like the witness statements, is preceded by a direction from the judge that the prosecution and defence have agreed these facts. In the same way that you can rely on the statements you've just heard as being true facts, you can do the same here, says the judge, but they have to be read into the record. The first agreed facts relate to WhatsApp. What it is, how it works, including the fact that users can see that others have visited the profile. The agreed facts state that the exchanges between the defendant and complainant, including comments on photos, have been exhibited. The facts also explain how messages can and when they cannot be deleted. Another agreed fact is that following his arrest, Tariq's phone was inspected and was the subject of questioning during his police interview under caution. Messages prior to the date of Ruby's interview weren't visible on Tariq's phone. He'd deleted all the messages between him and the complainant up to and including that day. The agreed fact lists the exhibited evidence, the CCTV footage from the bus, from the clothing store and from the pharmacy, all of which it's confirmed is Ruby, the 999 call in the original job advert. The final fact is that Tariq was arrested at his home address the day after Ruby's report. Mr. Neal now calls Detective Constable Elliott, the officer in the case, as his next and, as it turns out, final witness. It's 3:15. DC Elliott enters the court from the main entrance at the rear of the room and strides confidently to the witness stand. She's sworn in, and Mr. Neal gets straight to business. There's the usual preliminaries: name, rank, collar number, the station she's based at, the unit she works in. Elliott confirms she's the officer in the case and what this means, that she's responsible for the overall management of the investigation, collecting evidence and conducting further inquiries, all in pursuit of a charging decision from the Crown Prosecution Service. She confirms that there are codes of conduct governing her investigations and that she's under a duty to pursue all reasonable lines of inquiry, whether they point towards or away from a particular offence having been committed. And so we move to the first key topic of the prosecution's questioning of DC Elliott. She's made a number of inquiries, including securing CCTV footage from the cash point opposite Tariq's office. When he withdrew the cash he subsequently gave to Ruby. That footage was provided by the bank in the form of a link attached to an email. Elliot testifies that yes, she did view the footage. It showed Tariq and Ruby together. I could see the defendant and the victim approaching the ATM together, she says. The defendant was slightly ahead of the victim when he approached and used the ATM. He's seen to operate it and turned to her with what I suspect to be cash. Then they walk away, she says. How long did the footage last, asks Mr. Neal. Oh, no longer than 45 seconds. Can you remember the demeanour of the defendant and the complainant, asks Mr. Neal. Yes, says Elliot. There was nothing that stood out. They approached casually. She doesn't appear to be under any duress. This CCTV footage, however, is no longer available. DC Elliot explains that police computers require special licenses to download external material, not to view it, to download it. By the time she'd found a colleague with the appropriate license, the link to the footage had expired. Despite attempts to retrieve it, the bank couldn't resend the link. This footage, then, is essentially lost. The bulk of DC Elliot's evidence involves reading the transcript of Tariq's police interview, what he said when he was interviewed under caution following his arrest. Tariq didn't go no comment like a lot of suspects do. Instead, he provided a detailed account of the events of that day. Now, from what I understand, there's no legal prohibition on playing a suspect's video interview with police in court, but as a matter of convention, they aren't played in Crown Court trials in England and Wales, not typically. Instead, the transcript, or at least pertinent sections of it, are read aloud. It's a bit like those excruciating English literature classes in secondary school when the text you were studying was a play and the teacher dished out the different parts to students as you read a particular scene together as a class. That's what happens at trial, and it's what's happening here. DC Elliot takes the role of Tariq, and Mr. Neal reads the interviewing officer's questions. Reading that script now, the transcript of the interview, DC Elliot begins by confirming that Tariq's under caution, he's got an interpreter with him in the interview, and a solicitor. She confirms for the purposes of the tape that there's been disclosure to the solicitor prior to the interview, that the solicitor was given all the essential details sufficient to take instruction and be properly prepared for the interview. Although they allude to the same essential fact, Tariq's account is very different to Ruby's. I'll cover the main issues in his account here. But I'm going to be summarising what we hear of Tariq's account rather than trying to reenact a reenactment. Tariq's in the process of setting up his own business, he's saying. He needs staff, so he'd advertised on a website. Ruby had contacted him about a secretarial job. He says they talked about that being a voluntary role and that she'd agreed to that, to do voluntary work. Then, to the day of the rape, Ruby's attended his office, they've talked about the role in her training, then he's given her some tasks to do, research and so on. He says he needed to go to the post office at some point, so he left Ruby in the office on her own. When he got back, he says, he and Ruby were chatting and she showed him holiday photos, including one of herself in a bikini, which, says Tariq, he found surprising. He claims she performed gymnastics on a mat he laid out, that she danced with him to music she selected on his phone, and that as they danced, she embraced him tightly. She was the one who embraced me, Tariq says. She showed me how to do it, how to perform slow dancing. This is when I thought it was okay, and I thought we are more than friends or colleagues. He asked her if she'd go on holiday with him, and she said yes, she'd have some time in October when college had finished. He asked her if he could kiss her, and she'd nodded her head in agreement. Tariq claims he explicitly asked for Ruby's consent at every stage of their encounter. He'd asked if he could touch her hair, if he could kiss her, if he could touch her. I want to get her consent every time, he told police. I don't want to do anything without consent. And, he says, at some point during the encounter but prior to sex, his phone had rung. If Ruby wasn't consenting, Tariq tells the police officer, she could have made a dash for it then. Moreover, on Tariq's account, Ruby wasn't merely consenting to sexual activity, she was initiating it. I thought she gave me the green light when she showed me the photo in the bikini, and especially after, when she agreed to dance with me and all that. She also started all of this when she embraced me with her arms. She held me. She was the one who initiated everything, he said. It was Ruby who pulled her trousers down, and yes, he'd pulled at them lightly, but he tells the police, I said it doesn't feel right. And she did it herself. She pulled it down further. Tariq says that penetration occurred, but it was minimal and brief. As soon as I penetrated her, she asked me to stop, and I did, he says. I have not penetrated her fully when she's asked me to stop, but I ejaculated anyway. I ejaculated on her rather than in her. He says Ruby was in a very good mood before and after we've had sex. Her mood changed all of a sudden. I asked her what might be the reason. Not much was being said. Not much was said about why she wasn't being well. She just said she'd got appointments. And so before she left, I said I need to pay you for the sex that we had together. What was that, sorry? The interviewing officer asked. I said to her, I need to pay you for the sex we had together, says Tariq. I didn't mention the word sex per se. I said I need to pay you for what we just did together just now, and I need to go to the bank and to withdraw the cash to give it to you. I didn't have the cash. Tariq says Ruby agreed to that, and she had a few more words with me on the way to the bank, so yes, we went together to the cash machine. I'm sure there are cameras to prove what I'm saying. At the cash machine, I asked her how much, 10 or 20, and she said 20 would be fine. I withdrew £20 and gave it to her. Later on in the interview, when he's asked again about giving Ruby money, he says it was his idea, his suggestion, because from the way she spoke to him after they'd had sex, he felt she was asking him for money. He's asked if he uses prostitutes, if he pays for sex, to which Tariq responds, no, I have germophobia. Pardon, says the officer. I fear disease, explains Tariq. You fear disease, but you've met a girl and within an hour you're having consensual sex with her, unprotected, the officer asks. Yes, says Tariq. With the suspect interview now covered, Mr. Neal asks DC Elliott about cameras in Tariq's office. She says that police found a Wi-Fi camera in Tariq's office when they searched it, but it was either deactivated or it couldn't be accessed for footage. Mr. Neal doesn't have any further questions for DC Elliott, and the judge hasn't got any either, so it's straight into cross-examination with Miss Roberts. There's only really one thing Miss Roberts is interested in, and that's the missing CCTV footage from the bank's cash machine. Miss Roberts establishes a detailed timeline around this. When was the footage requested? 2 days after the incident. When was the link provided? 3 weeks later. And then it was another week before someone with the necessary download permissions was available, and that by that time the link had expired. So what you told the jury about your recollection of what was on the footage is what you can remember from that viewing? Asked Miss Robert. Correct, confirms DC Elliott. How many times did you view it? DC Elliott says that she's watched it maybe 3 or 4 times. Miss Roberts now presses for details about what the officer saw. The camera that shows the defendant and the complainant at the ATM, is it a camera that's in the machine or is it above it? It appeared to be external, says the officer. Could you make out who they were? Yes. And from what you could see, you've said nothing stood out. It was uneventful. That's correct. What you saw was the defendant approach and use the cash machine. DC Elliott nods. Correct, she says. And then hand some cash. Did you see him hand over something to the complainant? Asked Miss Roberts. Yes. And did she accept it? DC Elliott nods. Yes, she says. That's pretty much it from Miss Roberts, except for one final question, presented almost as an afterthought. In relation to this country, France and Spain, she asks, there's nothing recorded against him. Correct, says the officer. That's all I have for you, officer, thank you. It's 4:10. The judge asked Mr. Neal if there's other material that he wanted to play now. There is. It's videos of CCTV footage, which Mr. Neal now says I refer to with some trepidation. Checks need to be made before myself and the jury sit down to watch it, and then find out there's a problem, says the judge. She gives prosecuting counsel the remainder of the court day to do just that. Court adjourns until tomorrow morning. Join me in episode 2 when we'll be back in Court 1 for the remainder of Tariq's trial for rape and false imprisonment. If you or someone you know has been affected by any of the issues raised in this episode, please visit our website criminaljusticeinaction.com for information about support. Criminal Justice in Action is a Scrutiny Media production, researched, written and presented by Dr Candida Saunders, edited and produced by Candida Saunders and Gary Saunders, music by Alyonus Manova.